Party peoples of the interwebs, viva Fry, former Montreal litigator turned current Florida rumbler, in my home office yet again in Florida with Winnie the Westie, who could use a bit of a haircut. For those of you wondering, he's blind, so we don't actually need to trim the hair around his eyes because he can't see a darn thing. All right, people are asking me, and I haven't done a video about it yesterday because the judgment just came down yesterday. As at the time of shooting this vlog, I think it's January 17th, 2026. It's a Saturday. The ruling came down on a Friday, and it was a federal court of appeal unanimously upholding the lower level federal court from one Judge Mosley up in Canada, his order declaring Justin Trudeau and the Liberal government's invocation of the Emergencies Act to have been unreasonable and ultra vires, which is Latin for beyond the scope of, not within the bounds of the law, unlawful. Now, people have been, rejoicing in this decision because it's now 2026. We are now 4 years out of the invocation of the Emergencies Act. We are now years of torture, years of suffering, years of persecution of the criminal defendants in that case, and everybody's rejoicing that this is a big day for civil liberties in Canada, that the federal court unanimously upheld Judge Mosley's decision. It might be because I pulled my back out this morning, and I did, and it was excruciating. I've been in pain all day, that I might not be as enamored with this decision. I might not be as optimistic about this decision. I might not view this as the white pill, but rather I view this as something of the black pill. 4 years later, getting justice, and the only people paying attention to it are the ones who were victims of it, or the ones with an open mind who are willing to understand what went down. That does not include the vast majority of Canadians, in my humble experience. Now, taking some notes because I don't want to get anything wrong. You may remember such Ottawa trucker protest convoys as the one that yours truly, I was documenting among others, day in and day out, pretty much in Ottawa. This was to protest COVID measures. It was to protest lockdowns. It was to protest vax mandates. The truckers in particular who were saying, we don't need to get these vax mandates to cross the border. We basically have what is among the most solitary jobs on earth, and these vax mandates requiring COVID vaccination. And I'm not even using that word anymore because it's not a vaccine, in that it doesn't prevent contracting or transmitting the virus. It's at best a therapeutic, and as I understand now, it's a gene therapy, one that causes myocarditis in 1 in 5,000 young men per dose. So set all of that aside, there were massive protests in Canada. I was documenting it because at the time I was being told that there were Nazi flags, there was violence, there was desecrating the cenotaph, the war memorial, there was vandalism, there was harassment of people on the streets, there were people harassing the homeless shelter demanding food, and I had to go down and see if this was in fact occurring, and I went down and I documented it. If it was happening, the world was going to see it in real time. I didn't go down with an agenda. I went down because people were saying, Viva, you will not believe what's going on the street compared to what the CBC, the Communist Broadcasting Corporation, is announcing is going on. It was light and dark, day and night, truth and lies, truth and propagandas, and we all saw it in real time. During that protest, which spanned the better part of 3 weeks, we were hearing rumorings towards the end of it that Justin Trudeau was contemplating invoking the Emergencies Act. Now, for those of you who don't understand, and the ruling goes into the history of the Emergencies Act, it is the follow-up to the latest iteration of the War Measures Act. And it was specifically drafted to address some of the concerns about the War Measures Act, which oddly enough had been invoked and oddly enough had been abused by none other than Justin Trudeau's father, or alleged father, because some people think Fidel Castro is Justin Trudeau's father, but his father on paper, Pierre Elliott Trudeau, who invoked the War Measures Act during the FLQ crisis in the early 70s. The Front Libération de Québec, which was a separatist movement that were actually, putting bombs in mailboxes, actually kidnapping politicians. Pierre Laporte Ost was a man who was kidnapped and murdered by the FLQ during this uprising. Pierre Elliott Trudeau invoked the War Measures Act and abused of it to go after his political rivals. That was, I think, the only other time. There might have been a time earlier where the War Measures Act had been invoked. It was followed up by the Emergencies Act, which was supposed to put in place some safeguards to the abuse that we witnessed under Justin Trudeau's commie father, Pierre Elliott. So they invoked the Emergencies Act at the end of this protest, came down and literally beat the ever-loving piss out of veterans. Literally beat up veterans. Literally came in with concussive grenades, a militarized police force to brutally, violently, and savagely suppress what had only been the most peaceful protest in the history of Canada. And after you invoke the Emergencies Act, this specific piece of legislation, you have to have a commission that is triggered within, I don't know, I think it's 18 months of invoking the Emergencies Act to analyze the circumstances surrounding the invocation of the Emergencies Act. And we had that commission. It was under one Commissioner Rouleau. I love those birds. Those are little parakeets or whatever. They make a very cute noise and they're beautiful birds. It was Commissioner Rouleau. And we had whatever it was, a 6-week hearing on the invocation of the Emergencies Act. And Commissioner Rouleau, this is a political hearing, not a judicial one, came to the conclusion that it was okay that Justin Trudeau invoked the Emergencies Act. The circumstances were sufficient to warrant the follow-up to the War Measures Act, the brutal suppression of peaceful protest. But Commissioner Rouleau, in his ruling there, did conclude that canceling the insurance policies of the vehicles might have been a bridge too far, but freezing bank accounts, bringing in highly militarized police was justified, and Justin Trudeau was ratified in invoking the Emergency Act. That was a political process. In the interim, there was a parallel judicial process before the federal courts challenging the constitutionality of invoking the Emergencies Act, arguing that it was unwarranted, it didn't meet the threshold as provided for in the law, and that freezing of bank accounts, compelling or requesting banks to transmit information to the authorities violated constitutional rights. And Judge Mosley, a federal court judge, actually came down and said, yeah, it wasn't justified, it wasn't warranted, it was abusive, it did violate the constitutional rights of Canadians, whatever those are worth. You have a Charter of Rights, Bill of Rights, it's worth nothing. It's not worth the digital paper that it's printed on. But Mosley ruled that it was unconstitutional, that it did not meet the threshold, and the federal government, playing poker with the money of the citizens, no skin off their back, appealed the decision. And it just came down from the federal court yesterday, Friday, as at the time of shooting this vlog, and the federal court unanimously agreed that Justin Trudeau's invocation of the Emergencies Act and Chrystia Freeland, I think she was Minister of Finance at the time, the woman who is now the financial advisor to Volodymyr Zelensky, she froze bank accounts. She ordered banks to freeze the bank accounts of people who were participating in the protests, contributing to, organizing. And they in fact did freeze bank accounts of a great many people. I somehow escaped having my bank account frozen. I do remember that I gave $50 to the Go F Me fundraiser before it raised 10 million bucks, and then the government got involved and basically forced Go F Me to shut it down, politically pressured them into saying, oh no, the money's going to be used for violence and criminality, so we can't let it get to its end recipients. And then Go F Me actually said, we're going to keep the 10 million bucks that has been donated, and we're going to give it to a charity of our choice. They actually did that. And then there was an uproar. They said, okay, fine, ask for reimbursement, and everyone who gets the reimbursement, you'll get your money back, and whatever's left, we'll give to a charity of our choice. And then everyone's like, no, we're going to file contestations with the credit card company, and it's going to bog down your Go F Me of a company. And they finally said, okay, fine, we're reimbursing everything. Then I got my 50 bucks back, and then I gave $1,000 to Give, Send, Go, where they opened up a campaign. The monies ultimately never were able to get to the end recipients because Give, Send, Go was the object of a lawsuit, was accused of, all sorts of things. And they ultimately determined that they would not be able to disperse the funds raised in the manner in which those funds were raised for the purposes for which they were raised, and they reimbursed everybody. Now, that being said, we get to the point where the government brutalized all of these people, froze bank accounts of the people who had organized, participated in. Two of those individuals who actually had their bank accounts frozen were the applicants in this constitutional challenge before the federal court. The other one was, because you need to give him credit for doing the Lord's work, the Canadian Civil Liberties Association and the Canadian Constitutional Foundation were the other applicants in this lawsuit who took it all the way to the Court of Appeal on their own dollar. They got to raise the money to fight the government. The government dips its hands into your back pocket to finance its own corruption. The federal court came down and basically ratified Mosley's decision and said, yeah, they went through the whole history of the law. The history of it being it was the replacement to the War Measures Act, and it was supposed to set up certain safeguards so that the government would only break that glass in the event of a fire. You know, not because the pot's a little bit too hot, because the house is burning down. That's when you break the glass. And they had these measures inside the act, the threshold, the criteria that would require the government to justify invoking the nuclear bomb of legislation. And the government said, look, it was supposed to replace the War Measures Act. It was supposed to only be invoked when there was a national crisis that the existing laws were inadequate or unable to respond to. Now, there's only a handful of people that this is going to be full vindication for, and I'm going to put myself into that handful of people. This is vindication only insofar as it's exactly what I argued from day one. It's exactly what I said from day one, that on its face, invoking the Emergencies Act was unjustified. On the one hand, because you didn't have a national crisis, it was located in Ottawa, the capital of Canada. It was located within a 4-block radius in Ottawa, the capital of Canada. It wasn't a national crisis, but they tried to expand the definition to say financial harm was sufficient to justify invoking the Emergencies Act. And the Court of Appeal unanimously ratified Mosley and said, no, financial harm is not sufficient to justify invoking the Emergencies Act. And there's the other thing there, the Canadian Security Intelligence Service. There's a law there. It's like, Canadian intelligence, the CIA, where they say in their laws, they identify what is a national security threat. And the government was trying to argue that the criteria for national security issue, national security threat, risk, is broader in the Emergencies Act than it is under CSIS, the Canadian Security Intelligence Services law. And the judge said no, because if it were broader, then it would mean nothing in the other pieces of legislation. So he said, no, it never met the criteria, the threshold to justify invoking it. What they also said, which is what I said from day one, nobody was charged with anything other than standard criminal accusations, criminal charges for mischief, for counseling mischief. Nobody was charged with anything other than basic mischief under the criminal code. So how do you say we need to invoke the Emergencies Act using the laws that we have to punish the people that we now say, oh, we don't have the existing measures to punish these people, to put this down, we need to invoke the Emergencies Act? It never made any sense from the get-go. And then they tried to throw in that incident in Coutts, Alberta, where there was a cache of weapons and a cache of ammunition. Set aside the fact that that was all a big fat Fed trap. Let's set that aside. Just assume that, take it at face value, it happened. There were a bunch of people with guns and they were going to do something bad. They weren't. It's bullcrap. It's the January 6th of Canadian politics. But assume that it's true. The judge said, yeah, you can't invoke the Alberta Coutts guns and ammunition cache to justify invoking the Emergencies Act, because that had been addressed with existing criminal law before you invoked the Emergencies Act in Ottawa. Everyone remembers the blockade at the Windsor Passage, between Michigan and Ontario, as though that was the basis for it. Oh, the extreme financial harm, shutting down trade with America, it's going to hurt the car industry. That too was resolved before invoking the Emergencies Act to violently beat the ever-loving piss out of veterans who were protesting in Ottawa. People say, oh no, they were vandalizing the Cenotaph the War Memorial. Bullcrap. I was there. They weren't. Oh, they vandalized the Terry Fox Memorial. Bullcrap. They didn't. They put a flag in his hand and a hat on his head. Oh, they were harassing people at the homeless shelter. Bullcrap. They weren't. The Ottawa truckers were actually feeding the homeless, and I was there. We all saw it in real time together. So the court basically said, no, you didn't have to do it. There was no national security threat. There was no national crisis that could not be resolved by existing laws. And the evidence is that you resolved Coutts with existing law before invoking the Emergencies Act. And everyone that you charged at the end of the day with bullcrap mischief and counseling to commit mischief are all laws that already exist that you did not need to invoke the Emergencies Act for. They said it fell well short of the threshold that is required to invoke it. They said there were other legal remedies that they could have used and did in fact use. They got an injunction to end the Windsor blockade. And they said the provinces didn't even ask for this, with the exception of Ontario and British Columbia, two of the most communist provinces in Canada, which is already pretty communist. They said the provinces did not ask for the help. There was no crisis in the provinces that Quebec, which had its own protests and dealt with them accordingly, New Brunswick, Nova Scotia, Prince Edward Island. There were no crises in these provinces. The provinces never asked for it. The RCMP said we have the means to deal with it, and it was an absolute abuse from the get-go. They adjudicated that when it came to the banking issue, Chrystia Freeland. And I pronounce her name like that for a reason. It's because she has more of an affinity to her Ukrainian heritage, as evidenced by the fact that she is now financial advisor to Volodymyr Zelensky. She came out and said, "Yeah, we're gonna freeze bank accounts. No judicial process, no due process. You could just do it, and we'll immunize the banks from their having done it." You remember, it defies all logic. It proves that Canada is not a country that you can have bank accounts in, that you can do business in. Of course, Canada now cozying up to China proves that, if you had any doubt. Chrystia Freeland came out and said, yeah, we're going to authorize the banks with no due process, no judicial oversight, to unilaterally freeze bank accounts, to communicate information to the authorities with no court order, no court limitations, no clear specifications. And the Federal Court of Appeal came down and said, yeah, this violates unreasonable search and seizure, violates rights to privacy, where with no guidelines, no specificity, so much so the banks didn't even know what to do. From the ruling, it says that the banks were asking the cops, like the RCMP, like, what information do we communicate to you? They said, go on social media, see if there's any suspicious people that you need to report to us and communicate to us their information. Straight up communism. I mean, understand what that is. It's straight up Cuban, North Korean, Chinese communism. Very fitting now that Canada is getting further into bed with China, but set that aside. The judge said, yeah, all three of them, unanimously. It didn't make any sense. It violates privacy rights. There was no rhyme or reason to it. There was no order to it. And so many of you watching right now are saying, Viva, what's your deal? This is great news. This is a civil rights victory. Maybe it's the excruciating pain in my lower back talking right now. I don't view this as a victory for a number of reasons. First of all, nobody's paying attention 4 years later. There are people, they just want to move on with their lives. They want to forgive and forget. Get over COVID. Forget about it. The people who are paying attention to this right now are the victims of it, or the people who had a judicial interest, not in vindication at the end of the day, but in actually preserving civil rights. The vast majority of Canada and Canadians, I think, have zero insights, zero interest in this. They don't really care about it. They just want to move on with their lives. And many of them still believe the original lies. And if they hear about this ruling, they'll just go on with their days. So too little, too late. But the biggest problem, in my view, and I said this on Twitter, on X, at the Viva Fry. I mentioned this in our vivabarneslaw.locals.com community that got my analysis earlier this morning. This is not protecting civil rights. This is just giving the blueprint as to how the government can violate it in the future and protect themselves when they do it. Cautionary tales to some people are cautionary tales, and to other people, they're instruction manuals. And so when the court comes out and says, no, you didn't argue a national security adequately. No, you didn't say that the crisis was all across Canada. Oh, no, you didn't clarify what information needed to be given to you by the banks when you were asking for it. On the one hand, they say, yeah, ratifying civil rights, civil liberties. On the other hand, they're just giving the instructions to the government as to how they have to go about doing it the next time to not get spanked by the court. And I say spanked by the court. There are no penalties. There are no fines. Nobody's going to go to jail for this. There is no sanction against the very members of the government that violated Canadian civil rights and liberties. It's a declaratory judgment. Great, they did it. Shame on you. Now you know for the future what you've got to say if you want to do it without getting spanked at the appellate level 4 years down the line when half of you have jumped ship like the rats that you are. So there's no penalty against the government. Nobody's going to jail. And this actually will have zero impact on the criminal persecution that the likes of Tamara Leach, Chris Barber, Pat King, and others have experienced, because they were tried and convicted under criminal law. This declaring that they violated the civil rights of Canadians is irrelevant to that. Tamara Leach, Chris Barber, Pat King were convicted on mischief, not to mention the Coots Four, one of whom is still in jail. In fact, more than one, I think. It's not going to have any impact on their criminal convictions. It might help along with some civil cases for damages for violation of civil rights, but good luck asking for monetary compensation for civil rights violations when you've been convicted criminally. So even the remedy is illusory. It tells the government what to say in the future so they don't get caught with their hands in the unconstitutional cookie jar. Nobody's going to get punished. And so, good. I get to say I was right 4 years later. Everything that I argued from day one as I was walking the streets, vindication in the Court of Appeal. Great day for civil rights. We now know that we have a charter, and the government now knows what specifically they have to allege the next time they want to violate the rights of Canadians. God-given rights that the government can take away at will. And when they take them away, they cease becoming rights and they immediately become privileges that the government, after they've taken them from you, can say, you sure you deserve these? Have you gotten a little toxic jibby jab to get those rights back? So no, I'm not optimistic. No, I don't view this as a white pill. And we'll see if I feel any better when my back feels a little bit better. But it's going to lean over and pull up Winston. And we're going to say, if you like what I do, you know what to do. Like, share, subscribe, hit the notification bell, drop a comment in the comment section below, because YouTube is what it is. Your bladder feels like you have a lot of pee in it. And now you know you vlog, people. Peace out. Peace out. Booyah.
So we are aware of the court decision. We have discussed it with the Prime Minister, with cabinet colleagues, with senior federal government officials and experts. We respect very much Canada's independent judiciary. However, we do not agree with this decision, and respectfully, we will be appealing it. I would just like to take a moment to remind Canadians of how serious the situation was in our country when we took that decision.